there, thanks for joining us today. My name is Reddy Neumann. I'm an attorney and managing partner with Reddy Neumann PC. Every week on Tuesday at 5 o'clock Central Time, we come to you live to bring you the latest news in employment-based immigration and answer your questions live. Today I have with me Rebecca Chen, who is our partner and senior practice manager here at Reddy Neumann PC. Rebecca, what topics are we going to cover today?
Yeah, so today we'll go over some of the updates about the H-1B lottery registration system that's going to go into effect next month for the first time ever. We've been getting some updates on that. Also, last week there was some pretty big news in the concerning the unlawful presence memo that we've talked about several times over the past couple of years here concerning F1 students. There was a decision in federal court about that memo, so we'll talk about that. Also, we have new forms that were previewed last week that USCIS released on its website. These are the ones related to the public charge that's going to go into effect as a result of the federal court lifting the injunction for most of the country on that public charge rule that USCIS has been trying to implement for a while. So those will go into effect February 24th, so we'll talk about those a bit. And also we'll talk about some tips for filing in the H-1B lottery, especially whether it's a good idea to file multiple registrations for the same beneficiary. So we've gotten a lot of questions about that in recent days. So first up, concerning the H-1B registration process. So as we've been talking about a lot in these Facebook and YouTube live videos, the new H-1B registration process is an electronic system that is going to be open from March 1st through March 20th. And in this past week, USCIS has been conducting a series of webinars for employers, and then they held one today for attorneys for the first time to basically introduce and roll out its new registration system and give everyone a look at what it's going to be like. So it's not live yet, but it is going to be through the My USCIS portal. So you can already go onto USCIS and register an account in myuscis.gov. This is actually not a new portal. It's been around for several years now, and some people may have already registered an account through it. However, even if you have an existing account, you will need to register another one specifically as an H-1B registrant. So that's for companies who are planning to file H-1B applications for their employees in consideration for the lottery in March. Even if you have an existing petitioner account, you'll have to register another one as an H-1B registrant. And that option won't be available until February 24th. So February 24th is a pretty important date this month for a lot of reasons. So starting on the 24th, H-1B employers will be able to go on to MyUCIS and register their account as an H-1B registrant. What we found out from the attorney webinar that USCIS conducted today was basically how attorneys and legal representatives will be able to work with their employers. There will be basically a passcode that legal representatives will receive when they have registered on behalf of their clients that they will need to give the H-1B employers, and then that's how H-1B employers and attorneys' accounts will be linked up, and that's how attorneys will be able to submit registrations in the lottery next month as well. So, so far the system looks pretty user-friendly. It looks pretty straightforward. Hopefully it is that way and that everything goes as planned and that there aren't any glitches in the system. I mean, USCIS, even in its webinar, it has stated that they reserve the right to revert back to the old system. They're not expecting to, and we're hoping that it won't either, but yeah, so hopefully everything goes well with this new system.
All right, so only the employer has to create the MyUSCIS account. So individual employees, if you have a MyUSCIS account, it really has nothing to do with the registration process. You can continue to use it, but it's the employer now that has to create that account.
That's right.
All right. Also, last week we've had this ongoing discussion. We've talked a lot about the August 2018. We've been talking about it for a year and a half now. unlawful presence memo for F1 students. We talked about how this memo came out in August of 2018 and basically changed how USCIS looks at unlawful presence for F1 students. Normally, when an F1 student comes into the United States, they receive an I-94 that allows them to stay for what's called duration of status. There's no specific end date of an F1 student status. Based on some studies and reports that USCIS or DHS had done, they decided that they felt there was a problem with people overstaying on their student visas because they're given that duration of status without a specific end date. So they created this memo that basically said, if USCIS decides that at some point you violated your F1 status, they would count you as unlawfully present from the day the violation began. This was a huge change because it means unlawful presence is counted retroactively when you were not on notice that anything was wrong. So there was a court case filed, there was an injunction that blocked the memo for some time. Well, we finally got a decision in the court case, and the judge basically vacated the memo completely. That means the memo is gone, it does not take effect at all. So right now, the unlawful presence memo itself is unlawful. So there is no unlawful presence memo anymore. So we go back to what the original law was, which is that if a violation of F1 status has been found, starting from the day of that decision going forward, unlawful presence may apply, but it does not count backwards. So that's really important to know for the 3 and 10-year bar, so that if you have a situation where a decision is made saying you violated your F1 status, from that date going forward is when the time counts for that 3 and 10-year bar. There's no backwards counting. Even though this memo has been vacated, the issue really isn't going to go away, because we know that in the regulatory agenda, the Department of Homeland Security plans on proposing a new regulation that would cover the same topic. So I would expect that they're planning on, the reason that this memo was vacated is because they didn't go through the regulatory process. Now they're going to go through the regulatory process and try to get it done that way. So we're expecting a proposed regulation on this exact issue possibly this fall. Nothing's going to happen right away. Even once they propose it, nothing will happen right away. It's just a proposal at that point. It takes months to go through that process. So nothing is changing in the very near future, which is good news for F1 students who really had no knowledge that that anything wrong was happening, and it was really very big penalty to face for something you weren't even aware of. Okay, so what do we know about new forms that are coming out on February 24th?
Yeah, so these new forms, as we mentioned before, are results of the injunction being lifted for all states except Illinois on the public charge inadmissibility rule. So this was the rule that USCIS was trying to implement and actually rolled out forms for last year in the fall, until it was suddenly put on hold due to a federal court injunction. And then late last month, that injunction was lifted for most of the country, and so USCIS, as expected, is planning to include questions concerning whether applicants and beneficiaries are expected to become public charges on a number of forms, including the I-129, the I-539, I-539A supplement, the I-485 application. And so USCIS rolled out sort of the preview of these forms late last week, and they are along the lines of the forms that they had introduced last fall as far as the questions concerning has the beneficiary or applicant used local, federal, or state income assistance, benefits related to TANF, which is Temporary Assistance for Needy Families, food stamps and related programs like WIC. For the most part, I would say for employment-based applicants and their family members, most of these won't have a big impact, as we've mentioned before in these sessions. They shouldn't have too much of an impact on your extension or change of status application or on your I-485 adjustment of status application, because for the most part, especially if you're in H-1B status, for example, you're required to be paid a minimum amount according to the prevailing wage that is likely to keep you above the level of needing government assistance for income maintenance and that sort of thing. So it's mostly going to be additional questions that applicants and beneficiaries are going to need to answer. Kind of the only thing that's outside of that is the additional form about self-sufficiency that is going to be required for all I-485 applications. So that form does seem pretty extensive. It's going to require applicants for I-485 applications to include their credit report if they do have a credit score. So that is, it looks like that's going to be more of an involved process. So at least in the near term, if you or your employer has started any applications, drafted any forms on the current version, make sure those are filed with USCIS before February 24th. They will accept current versions of the form for any packages postmarked before February 24th. After that, they will only accept the new version.
All right. So yeah, that I-485, if you're able to file that this month, you may want to file it before February 24th, so you don't have to worry about including your credit report and that new I-944 form. Lastly, one of the most common questions we're getting right now, so those of you who watch this regularly know that we do conduct a daily conference call that's free for people to call in and ask their immigration questions. We have our blog, immigrationgirl.com. We have our Facebook page, Twitter, YouTube, all of these different sources. And so we get a lot of questions every day. And right now it feels like one of the most common questions we're getting is, can I submit 2 different registrations in the upcoming lottery to increase my chances? So we wanted to cover that today. We've talked about this before, but we wanted to the question keeps coming up regardless of how many times we say the answer is no. So 99.9999999 times percent of the time, the answer is always going to be no. Even if they're 2 separate companies, you are running a huge risk that, number one, USCIS is going to question whether they're 2 separate companies. There was actually some litigation on that not too long ago where the 2 separate companies filed petitions that just looked a little too similar, and so USCIS went back to revoke both of them, and the company filed a lawsuit saying you can't do this, we're not related to each other, and they couldn't overcome the issues that were raised even in the lawsuit. But even if the 2 companies are completely separate, 100%, nothing related between the 2, we're always hearing my employer that I'm working for right now is filing, and I found some consulting company that wants to file for me. They claim they have a project for me. Please be careful of those. You have no idea how many other people that consulting company is telling the same story to. They might be planning on filing 200 of those. You have no way of knowing that. And you're putting your life in this person's hands. If you don't know them, you don't know, the company could just shut down next month and they run away and they're fine, and you're left with a potential of fraud or misrepresentation. We've seen that from prior years when people filed 2 petitions in the lottery, get both of them approved. Everyone thinks that's great. They only work for the valid one, the one they were actually working for from before. Well, when they go for stamping, they're getting their visas denied because of fraud or misrepresentation that was committed in the other company's filing. We're also seeing that when you're filing an extension or a transfer, a change of status, the issue is popping back up. So this is a trap. You are going to be submitting multiple registrations, and if you're selected 10 times, maybe you'll have 10 companies filing these petitions on your behalf, and you'll go with whichever one works out the best. They're going to approve all of them as a way to get additional documents so that they can later come back and find fraud, find misrepresentation, and revoke everything. So please, we highly recommend against doing that. It is not safe to do that, no matter what these companies say. If they claim they have a project, if it's a friend of a friend of a friend. Heard so many people getting into trouble because a friend of a friend recommended someone. One thing you can do to, protect yourself a little bit is, there's a data hub on the USCIS website where you can type in the company name and see how many petitions they've filed in the past. Are they filing 300 and they only have 5 employees, or are they filing a normal number of petitions? Look at how many have been denied. Look how many have been approved. You'll find some of these companies filed 300 petitions and end up with 295 denials.
Yeah.
Maybe that's not the best company to file your petition with. It's just not worth it. Any other points you have on that?
Yeah, just that especially this year, we already know that the government from the past couple of years has been increasing their intention on duplicate filings. So this applies to the same beneficiary being filed for different companies with different tax ID numbers. And we know that it's been an increasing focus because for the past 2 or 3 years, it's taken the government longer and longer to send back the unselected H-1B applications that are filed every April. Why would they want to hold on to those hundreds, those thousands of unselected applications? We know that it's mostly for data mining purposes in order to figure out which beneficiaries have had multiple companies filing applications for them and then going in and investigating how many of those job offers are legitimate. This year with the electronic registration system, there are a lot of advantages. It's much more efficient in many ways, but it's also much more efficient for the government in order to collect and find information. We're basically entering all the information for them in a database, and it's going to be very easy for the government to go through and see what beneficiaries have had multiple companies filing for them and then take their investigation from there. So, another thing to keep in mind is that we understand the impulse to want to increase your chances in the lottery, especially this year when it's expected that the lottery is going to increase in the number of registrants from last year. But you have to consider how much more is, one additional registration going to increase your chances. It's a fraction of a percent that it will increase your chances, but we know for sure that the government is paying attention to multiple registrations. So just one additional registration is going to put the government's focus on you. How much is that worth versus, the fraction of the percentage of that it might, increase your chance by.
All right, I think we can head to some questions today. Sudhir from YouTube wants to know if he can register without the employer in the upcoming lottery. So unfortunately, only the employer can register on your behalf. So the employer is going to create an account in the My USCIS website. For all of the people they intend to sponsor, the employer will enter your name, passport number, date of birth, country of birth, whether you're filing under the bachelor's cap or master's cap, and only the employer then will submit that registration. USCIS will go through them and select all the registrations in either the bachelor's cap or the master's cap and inform the employer by March 31st who's been selected so that they can begin filing. So it is all going to be based on the employer.
Okay, Somit from YouTube has a question about the registration system. Do we need to provide client information in the registration system? So the answer is no. The H-1B registration system asks for very minimal information in order to submit someone for the lottery. It's the company information, including the address, signatory, tax ID number. And then as far as the beneficiary, it's basic biographic information, date of birth, full name, passport number, and then, of course, whether you have a U.S. master's degree, that would put you in consideration for the master's lottery. It does not ask for any information about the position, about the specialty occupation, about the qualifications. So it definitely does not ask for any information about the end client or the vendor. That doesn't mean that that information won't be important. If your registration is selected, you will still need to provide all of that information in the I-129 petition. So all of that will still need to be provided in the full petition that is filed with USCIS. So that should still be part of the initial review, but it won't be required upfront.
Vivek from Facebook, his wife has attended her H-4 visa interview at the consulate and received a 221G because his H-1B approval actually has an intent to revoke on it. At least it did at one point. He's already transferred to a new employer, has a new approval, and wants to know if his wife can attend the visa interview again. So yes, she should be able to do so using your new approval notice. I would generally recommend that she withdraw her current application, submit a new DS-160, pay the new visa application fee, enter in your new information, and then she can schedule the interview. Depending on the issue, though, that's going on with this notice of intent to revoke, without knowing all the details on that, you might want to discuss with a lawyer, set up a consultation to review what were the issues raised in that intent to revoke to ensure that it's not going to cause any issues for her new visa stamping.
Karthik from YouTube is asking, does the PERM application require current H-1B information like client and location, or if the employer information is enough? So for the PERM application, you are not required to prove maintenance of H-1B status. You don't have to provide project documents the way that you have to with an H-1B application, because the PERM application is part of the green card process, which is technically for future permanent employment. You don't even need to be in the U.S. technically in H-1B status to have a PERM application filed for you by an employer. So that's not required, although if you are working in a situation where you're at an end client site and you change projects pretty regularly, your employer and attorney are going to need to take that into account. There is specific language that is usually included in the PERM application if it's expected that your work location could change pretty frequently as part of this permanent job offer, and there are specific rules about where the advertisements need to be done in that situation, so it still affects your PERM application.
Deal from Facebook wants to know, he was previously on F1 in the United States, and after his STEM extension ended, he stayed in the U.S. for 60 days beyond the 60-day grace period. He wants to know if he's coming back again for a master's degree, should he be worried? It's definitely something that has to be disclosed in the new visa application. So when you submit your DS-160 visa application, it does specifically ask, have you ever failed to maintain status in the U.S. or violated your status? You will have to answer yes to that because you overstayed beyond your grace period, and you'll be given an opportunity to explain it. But having stayed for 60 days, generally it's not a ground of inadmissibility. That means that you can still be approved for the visa even with that 60-day period. What makes you inadmissible is unlawful presence of more than 180 days or a misrepresentation. So if you fail to disclose that in the DS-160, they could deny your visa for the misrepresentation, not for the out of status time.
We have a question from someone on YouTube who said he received a DWI about, it looks like 8 years ago now, while he was in F1 status, and since then has changed to H-1B, and it looks like adjusted status and received the green card since then, and is planning to travel outside the country, and is asking if there will be any issues at the port of entry as a result of the DWI. Most likely not. Coming in at the port of entry with a green card, for the most part, I haven't heard of officers at the border going into a DWI history for green card holders for the most part. So most likely not, although the government is looking into everything now. They're looking backwards into everything, and we have seen a number of cases where at the N-400 naturalization application, the government looks back into the applicants, not only how they got their green card, but during their non-immigrant period of stay. So I would consult with an attorney for this, for this person asking the question. Make sure that the DWI was disclosed at the I-485 stage if you filed an I-485 application. If it wasn't, then it could affect your N-400 application later.
All right. Vimuli from YouTube has an H-4 pending for over 240 days and needs to file an H-1B extension coming up in May. If the H-4 is still pending at that point, he wants to know if the H-1B extension filing will be an issue. So I'm assuming that you're talking about two different people here. So one person needs an H-1B extension, the spouse has an H-4 extension that's pending. So the pending H-4 extension would not have any impact on the spouse's ability to get the H-1B extension. And you would also be able to file your H-1B extension with another H-4 extension to continue the stay so that everyone will end up with H-1B and H-4 approval notices beyond May 2020 and with the same end date.
Tanvi from YouTube is asking how to avoid an RFE issued for a level 1 wage on the LCA. So yeah, that is an issue that we started seeing in the summer of 2017 when for the first time ever USCIS started sending requests for evidence claiming that because the position was listed in the level 1 wage category on the LCA, they were questioning whether it was really complex enough to be considered a specialty occupation. So we responded to a number of those RFEs. It is good to be thinking about that up front before you are filing the LCA and before preparing and filing your petition. Obviously, one way to avoid it is to file with a higher wage in level 2 if possible. We know that's not always possible and it's not always realistic for F1 students, especially considering who are changing status to H-1B. Most of the time they are entry-level employees. It's your first job out of school, and so it makes sense that your employer is paying an entry-level wage. So if it is not possible for your employer to offer you a level 2 or higher wage, I would say we have responded to a number of RFEs on the level 1 issue and gotten approvals if we are able to sufficiently show that the position is still a specialty occupation. It does require, it may not avoid an RFE, although there are ways that you can draft the job description with more specificity up front to make it clear that it is a specialty occupation even though you will be under the supervision maybe of senior professionals, senior engineers or architects or whatever your position is, that even though you're working under them, you're still doing a specialty occupation. So you may be able to avoid an RFE that way. Even if you cannot avoid an RFE, there are ways to overcome the RFE by showing that your position is still complex enough, even though it's an entry-level position.
Raman from Facebook wants to know if filing 2 H-1Bs with 2 different employers and both are selected, can he just drop one? What's the issue with that? So first, we again don't recommend that. The problem is if you drop one, so USCIS is actually keeping track of employers who receive registrations and are selected but don't follow through with the filing of the petition. So the employer could be harmed by you doing that. If you file 2 applications with 2 different companies and you only decide to proceed with the petition with one, that other company could be found to be misrepresenting or fraud or barred from using the H-1B in the future because they didn't move forward to actually file the petition. Now, generally they're looking for a pattern of that practice, but I would not want to put the employer in that situation either if the employer is a genuine company who truly wants to sponsor you for the petition.
We have a question from YouTube from someone who changed status from F1 to H-1B. They say they don't have a stamp in their passport and last week they were laid off by their employer, and what are their options now? So if you are in H-1B status, it's okay if you never traveled and got the H-1B visa stamp on your passport. If your H-1B application was approved as a change of status from F1 to H-1B and you did receive the I-94 and you were working in H-1B status, then the good news is you do have a 60-day grace period. If your I-94 is not yet expired, which hopefully it hasn't been yet, then you have 60 days from the date that you were terminated by your H-1B employer, and that 60 days allows you to find another employer to file an H-1B transfer application for you, or if you file a change of status application to a different non-immigrant status, then USCIS will not consider the application as filed late if it's filed within that 60-day period. So I would say that would be your first option, hopefully, to find another employer who can file a transfer within 60 days.
Sukesh from YouTube wants to know if an H-1B that was approved for consular processing can be extended so that you can continue on H-4 EAD and then still use the H-1B in the future. So, this situation comes up, say you filed an H-1B requesting consular processing because you have valid work authorization. You don't necessarily need to use the H-1B right away. And now that petition that's approved is about to expire. So we've been successful in extending a consular processing H-1B approval only where it's the same employer who already received that approval. Now they're seeking to extend it because you weren't able to use it within the approval period. Another employer would not be able to use that because you never got the visa stamp or entered H-1B status, so you're not technically considered counted in the cap yet. But we have done it when it's the same employer filing that extension.
Goldie from YouTube is asking about work on an H-1B with a client that is recently changed, and it looks like the amendment was filed and is currently pending, and he wants to know if an H-1B transfer can be filed at this point. So it does depend quite a bit on whether your I-94 has expired or not with Company A. So if the I-94 is not yet expired from the previous approved petition and you just have a pending amendment application for the change in work location, then you should be able to file an H-1B transfer without a problem. As long as you've still been working for Company A, can provide pay stubs, the transfer with Company B should be able to go through without a problem. If the I-94 with Company A already has expired and it's an amendment plus extension that's pending, then you're technically in a period of authorized stay now. If you file an H-1B transfer now, it probably will not be adjudicated until that amendment plus extension application is processed. So in that situation, if that is the case, you'll want the amendment plus extension application to be upgraded to premium if it's not already approved before you file the transfer and move.
Raj from YouTube has a tax question. He wants to know, he filed the 2018 tax return and forgot to report a small amount of interest that the bank sent on a 1099 later on, and wants to know if he needs to revise the 28 tax return or not. Well, certainly we are not tax attorneys, we're only immigration attorneys. I can tell you from personal experience, I've done that before, and I got a lovely letter from the IRS a couple years later saying I owed more taxes and a lot of interest on those owed taxes. So my recommendation is talk to a CPA right away to find out if it's something that you need to correct or not. But don't play around with the IRS.
Kapoor from YouTube is asking if there are any updates in Senate Bill 386. So as many of you know, this is the bill that proposes to remove the per country caps on the immigrant visa, which would eliminate much of the backlog in the categories for Indian and Chinese nationals in the employment-based and in the family-based categories. The corresponding bill in the House passed last year, and as we know, it's in the Senate now. As far as I know, there haven't been any updates. It's basically stuck there for now. It's believed that if it was brought to the floor for a vote by the Senate Majority Leader, that it has a pretty good chance of passing. There is, pretty good bipartisan support for the bill, as we saw in the House. It's just a matter of getting the bill to a vote. And so if you've been watching these sessions in the past, we've been encouraging people to contact your representatives. You do not have to be a green card holder or a U.S. citizen in order to contact your local congressperson, your local, the senator in your state, in order to make known your support of this bill and how much it would impact your immigration case. So we still encourage people to contact your representatives about this bill.
Yeah, especially now that the whole impeachment mess is over with, maybe the Senate can actually get some work done.
Right.
Dipjyoti from YouTube currently has an H-1B and wants to know if she can work part-time, he or she, sorry, I'm not sure, in a university. And at the same time, can you have two H-1B employers, one full-time and one part-time? And the answer is yes, you can definitely do that. The second employer, in your case the university, would be filing a concurrent H-1B. And you can request part-time employment there. You can specify the number of hours you'll work during that time. Filed with USCIS just like any other H-1B, and you get an approval notice that allows you to work for both employers at the same time.
Deli, I believe from Facebook, is asking if they were working on OPT or STEM OPT and then file for an H-1B application, would USCIS ask for tax returns or pay stubs? So if you are filing a change of status application from F1 to H-1B, if you have been in STEM OPT under the rules for the STEM extension, you are required to be paid by the employer, and so in those situations, pay stubs would be included with the petition as proof that you are maintaining your F1 OPT STEM extension status, that you're maintaining status. For the most part, I haven't seen USCIS requesting personal tax returns very much from beneficiaries. I don't think that will be necessary, but pay stubs, especially if you've been in the STEM extension, even if you're in OPT, if you've been working in a paid position, you should still attach pay stubs as part of the petition.
Sandeep from YouTube wants to know if we have an experienced crimmigration attorney here at Reddy Neumann PC. So crimmigration, if I can say it, refers to immigration attorneys that have experience with criminal law and how exactly it impacts immigration status. I can recommend Ryan Wilk. He's one of the attorneys here in our office. If you go to our website, rnlawgroup.com, you'll be able to find his information and you can actually set up a consultation with him, Ryan Wilk.
Sam from YouTube was asking that for someone in the initial OPT period who changes employers, if the employer's not willing to, it sounds like, issue an experience letter that specifies the number of hours worked, will that be an issue for the STEM OPT? I don't think it would be an issue if the employer is willing to provide a letter confirming the OPT employment. That's usually all that's needed. Actually, that's not even really needed to apply for the STEM extension. With the I-765, you're not required to attach copies of experience letters from the initial OPT period. It is best to have letters of experience from your OPT period if possible, especially if your goal in the future is to apply for a green card at some point. It's helpful to have experience letters from all your employment, especially from OPT, if it could end up being used to qualify you for the permanent position later. But yeah, it won't be required for the STEM extension.
Mayank from Facebook has a friend who is hitting the H-1B 6-year limit in April of 2021. The current employer has not yet started the perm process, but plans to do it in June. He wants to know if it would be a good idea to switch the employer in the next 3 to 5 months, or is it too late? It's really important to be aware that the prevailing wage request for the perm process is taking longer. It's taking almost 5 months now. And then once you file the perm application, it's also taking longer, 4 to 5 months now. And so if the employer's not getting started until June, there's a very high likelihood that you won't be able to get the labor and I-140 both approved in time to be able to extend the H-1B based on the AC-21 7th year extension. Switching employers in the next 3 to 5 months is also not super helpful because, again, if the new employer is starting 3 to 5 months from now, that's way too late. It's going to be very difficult to get the perm and I-140 approved, and you have to have the I-140 approved in order to extend the H-1 because the perm was not being filed before you finished your 5th year. So the better option may be to take some strategic vacations or trips outside the U.S. so that you can recapture more time to buy enough time to be able to later extend based on the approved I-140.
Dipjoti from YouTube is asking, it sounds like the question is about concurrent H-1B employment. He or she has a H-1B, it sounds like, for full-time employment right now, and is asking if a second H-1B for part-time employment is filed, will it affect the first approved H-1B? It should not. So the second H-1B would be filed requesting concurrent employment, which is possible as long as you're able to put in the hours required for your full-time H-1B employment, as well as the part-time concurrent employment that you're filing the second petition for. For the most part, it shouldn't affect your first approved H-1B unless for some reason there's something in the second application that would call into question your employment with the first petition. But if they're in similar positions in the same city, if it makes sense basically that you could realistically work that number of hours in 2 separate positions, there shouldn't be a problem.
Nikhil from YouTube wants to know what happens to H-1B applications that are selected in the lottery but then ultimately denied. Does USCIS go back and select more in order to fill those empty slots? So get this question a lot. It's very common. And what USCIS does is they actually select more than the required number. So we know that there's a 65,000 visa cap, and then 20,000 extra go to the master's cap. So we have a total of 85,000 that they try to get approved. But every year USCIS knows a certain percentage of petitions are ultimately denied or withdrawn or are revoked. And so they actually calculate what they think that percentage is going to be and select extra petitions every year. So last year, they did not select 60,000 petitions, they selected 75,000 or 80,000, I think, somewhere in that range. I apologize. The actual numbers are on my blog, immigrationgirl.com. But they selected extra in the master's cap, and then they selected, I believe, an extra 5,000 in the master's cap, extra 15,000 in the bachelor's cap. So I think it was a total of 100,000 petitions that they actually selected. And they do process them completely because they know that approximately 15,000 are ultimately not going to be approved or are going to be withdrawn or revoked. So there isn't really a wait list. They do talk about a wait list in this new regulation, but I think that's more the situation where they didn't fill the lottery to begin with and then they add more. But here, we're pretty sure there's going to be more than 85,000 people registering, so there is going to be a lottery and they are going to select the extra to fill those slots before they actually get denied or withdrawn.
MR from YouTube is asking what happens when there's an inconsistency, it looks like, between the worksite address on the LCA and the I-129 form. The inconsistency that he or she is describing looks pretty minor. It looks like the same address, but the difference is calling it a street versus drive. In that situation, I think there shouldn't be any effect on the H-1B application overall. If it's pretty clear from the LCA and the I-129 form that it's referring to the same work site, I don't think there will be any issues. But if it was, a completely different address on the LCA and the I-129 form, that could be problematic.
Joel from YouTube has an H-1B petition that was selected in the lottery last year that's still pending, and his statement of work is going to expire this month. Unfortunately, it really never should have gotten to that point because premium processing has been available. This could have been upgraded and you could have had the approval. And now if that statement of work is not renewed and you end up with an RFE at this stage, the petition very likely could be denied. And there's not really any option there other than making sure that that statement of work gets extended so that hopefully if there's a request for evidence, your employer will be able to show that the work continues to be available.
Sankit from Facebook is asking what is the best time to apply for an L2 EAD extension. So the L2 EADs are unfortunately in the same boat pretty much as the H4 EADs, which means extensive delays, mostly as a result of the delay in I-539 processing because of the biometrics requirement. So it is still usually the best bet to file, I would say, the L1, L2, and I-765 applications concurrently in premium processing. The L1 will hopefully get approved pretty quickly, but the L2 and EAD applications could be pending for a long time. One option to consider is filing a lawsuit in federal court. So it's pretty much the same fact pattern as the H4 EAD delay suits that our office has been filing. Our litigation team just filed one last week for people whose EADs have been delayed by several months due to the I-539 delays. So typically when someone joins a lawsuit, what we've seen is a turnaround in about 60 days usually. So it's still, longer than preferable or longer than it used to be before March 2019, but it's still several months faster than if it remains in regular processing.
Srinivas from YouTube wants to know what the status is of the H4 EAD. Is it going away in the near future? So we do know that Department of Homeland Security intends to propose a new regulation that would eliminate the H4 EAD. They have not proposed that. They've been intending to propose that for 2 years now, and we still don't have a proposal. The latest update was that the earliest we would expect to see a proposal is spring of 2020, so possibly March or April. Could be delayed beyond that. And again, that would just be a proposal. It's not a final regulation until they actually go through the whole regulatory process. That takes a good 6 to 8 months, if not longer. Normally it does take longer. And when they finally go through that process and issue a final rule, that final rule takes effect in the future, usually 45 or 60 days in the future. So nothing is happening in the very near future, and I would expect that by the time a final regulation does finally get passed, you can guarantee there's going to be litigation seeking to block that regulation. So nothing is expected to happen in the very near future with the H4 EAD.
Pinky from YouTube is asking about his I-140 that was filed in the EB1C category. It's still pending. But if he switches jobs 180 days after it is approved, can he preserve the priority date for a future EB1C filing? So the answer technically is yes. If an I-140 remains approved for 180 days, even if the petitioner withdraws it after that, that I-140 approval can still be used by the beneficiary for purposes of extending an H-1B status beyond the 6-year limit, for the purposes of preserving the priority date and porting it to another I-140 approval, and for purposes of the spouse to obtain an EAD if they're in H4 status. So it's still usable in all those situations. The question is more, I suppose it's less common to move to another employer and to be able to file an EB1C application, because if your I-140 is in EB1C, that is the category for multinational executives and managers, and that has pretty particular requirements of your foreign employment with a parent, subsidiary, or branch of the U.S. petitioner in the 1 year out of the 3 years immediately preceding your entrance into the U.S. So if you're moving to a different company or a different organization, it's likely that you're not going to have that qualifying relationship there anymore to be able to file another EB1C application through that company. So that's why I would say that situation, that porting situation, is less common. We don't see it as much, but technically you can preserve that priority date to move to a different I-140 approval.
All right, Sue from Facebook had an H-1B approval a couple years ago, stopped working in July 2019 due to pregnancy, and applied for an H-4 and H-4 EAD at that time. The H4 and H4 EAD are of course still pending, and now she has a job offer from a new company. So she wants to know if she can file an H1 transfer now and work for the new company while it's pending. So you can switch back to H-1B. However, because you're no longer in H-1B status and you're not yet in H-4 status, you can't start working based on the filing of the transfer. You have to wait until it gets approved. On top of that, when you file, because you're not currently in H-1B status anymore and you're not yet in H-4 status because it's not approved, you're in a period of authorized stay. So very likely your new H-1B is going to have to be requesting consular processing so that you go out and come back in order to get and regain your H-1B status, because you have to always prove whenever you're filing anything, whether it's an extension or a transfer or a change of status, that on the day of filing the application you're maintaining your current status. And technically you're not maintaining any current status because you're not in H1 anymore and you're not yet in H4. You're legally allowed to stay because you're in a period of authorized stay, but that is not the same thing as maintaining status. So most likely in this situation, what we would generally do is have the new employer file the H-1B in premium processing, request consular processing. If your H-1B visa stamp that's in your passport is still valid, it hasn't expired, you can go out and come back in with the old employer's visa stamp and your new employer's approval notice, and then start working in H-1 status.
Pudota from YouTube is asking about filing an H-1B for a remote job and any suggestions. I'm assuming that you mean working remotely from home. If that's the case, then that is entirely possible. Excuse me. We have filed H-1B applications many times for beneficiaries working remotely from home, as long as there's still the requisite employer-employee relationship, as long as you can show that there is a way that your H-1B employer is still supervising you remotely, that you're still in touch with them, that they're reviewing your work, that they're doing your performance reviews, that you are in touch with them regularly. We haven't seen any problems with filing an H-1B application listing a home address as a work location.
Shreyas from YouTube wants to know, what are the chances of H-1B approval from a hospitality hotel corporation? Well, the short answer is it depends. There's just not enough information. So what you're looking at, number one, is what is the job that you're being sponsored for? If this hotel corporation is sponsoring you for a janitor, then of course the chances are practically zero that you're going to get approved for that. But if they're sponsoring you for something that normally does require a bachelor's degree in a specific field of study, and it is a very detailed job description that shows that it does require a degree, then it can be approved, assuming that the company that's filing for you has sufficient specialty occupation work available. So they do look into the company as well to make sure it makes sense. It's reasonable that that type of company needs your type of work for a full 3-year period. I mean, we see sometimes where like gas stations file for accountants. That doesn't make any sense. Why would a gas station need a full-time accountant for 3 years? That's very unusual. Those typically are denied. So it really depends on all the exact circumstances. It's not impossible, but not enough information to know how successful it could be.
Naveen has a good question about the H-1B filings for April in the quota, whether there will be premium processing available. So as of now, USCIS has not stated one way or the other about premium processing. We've seen in past years that they've made an announcement as late as, I believe, the end of the first week of March sometimes. I think that was a couple years ago that they announced on March 8th that there was not going to be a premium processing option. As most of you know, probably last year they did allow premium processing as an option for the CAP subject H-1B applications, and we are hoping that they will continue that this year. My guess is most likely they will allow premium processing again this year, especially with the longer filing window. We have 90 days from April to June 30th, and USCIS is a bit more in control of the process with this new registration system, they'll only receive applications that have been selected, and they've specified that selected applications will be told which service center to file at, presumably for workflow and workload situations. Because of all that, we're hoping that that means USCIS is in more control of the influx of applications that they'll be receiving, and that they will allow premium processing for that reason, hopefully, but we don't know for sure yet.
All right, Eka from YouTube is currently on an O1 visa and recently got an I-140 petition approved in the EB1A category. Congrats. The I-140 petition was filed requesting consular processing, and you want to know if you can instead do the adjustment of status process when the priority date becomes current. Yes, you can, as long as you continue to maintain your existing non-immigrant status or any non-immigrant status. You can always change your mind and convert a consular processed I-140 to adjustment of status by simply filing the adjustment of status. There's no extra anything that you have to do. You just file the 485, pretend as if you never said consular processing. That's totally fine.
Kieran from YouTube is asking if you're on an F1 visa with OPT work authorization, are you authorized to be trading stocks? So we've talked about this a few times on these sessions before. It really depends on your involvement in the company. If it's purely holding stocks and buying and selling stocks on the stock market, that is fine. There's no problem with people in F1 status, H1 status, L1 status doing that with just holding stocks in a company. If it's to the point where you are an owner in that company and holding a majority or a significant portion of the shares in a company, that starts to kind of creep into the territory of whether you are actively managing that company, if you're involved in the day-to-day operations of that company. If so, then that is probably unauthorized work, because that is work that you're not authorized to do unless it is related to your OPT field of study. So it kind of depends on how involved you are with the company. If it's just owning stocks in a publicly traded company, that should be fine.
All right, I think we have time for one last question. We'll take one from Praveen on Facebook, who wants to know if the H-4 EAD application can be filed more than 180 days prior to the expiration, and if so, does the H-4 extension also need to be filed? So yes, if your H-4 and your EAD are expiring at the same time, and you plan on filing the H-4 EAD extension early, you also need to have the H-4 extension filed, because the EAD cannot be approved beyond the current period without having the H-4 extended as well. Can you file more than 180 days in advance? Yes, assuming that your spouse's H-1 has already been approved beyond the period your current EAD is valid for. So the EAD is dependent on the end date of the H-4, which is dependent on the end date of the H-1. So if the H-1 hasn't been extended yet, then there's nothing for you to extend on your H-4 and EAD unless yours are shorter than the H-1B extension is. But for example, if you have your H-4 and EAD that are valid until December 2020, and now your H-1 spouse is filing a transfer, absolutely, you can all three file the H-1 extension to request 3 years and file the H-4 and the EAD at the same time. So you'll all get that extended validity period till 2023, even though it's more than 180 days before your current H-4 EAD expires. I think that's about it for today. Thank you so much for joining us. Thank you, Rebecca, for filling in.
Thank you.
And remember that we do have a daily conference call that you can dial in. It's free. Go to rnlawgroup.com to get the dial-in information for that and the timings of it. And please, you can always subscribe to our newsletter by going to RN Law Group. You can subscribe to Immigration Girl at immigrationgirl.com. Follow us on Twitter, RN Law Group, or Immigration Girl. Thanks so much for joining, and we'll see you again next week.